President Jonathan was sworn in as president on the 5th of May, 2010. So he spent a year before he contested in 2011 and won the election. So he's done 5 years already. He's therefore disqualified from contesting another election for a 4-year term. That means he will spend 9 years in office. Now, people are saying, oh, the law will only take effect when it was made in 2017. I will have been persuaded to go along with that argument. But in the case of Tony Obayori and Musa, Tony Obayori and PDP, the Supreme Court held that alteration, fourth alteration, number 21 of 2017, which came into force in 2018, affected the pre-elections that were filed in 2015. In this case, in these two cases, the appellant filed his pre-election cases in 2015. This law came into force 3 years later. And we tried to convince the court that the law cannot be retrospective. And the Supreme Court said no. An amendment of a constitution can be retrospective. And in this case,
there is the law, there is constitution, and then there is a pronouncement of the Supreme Court. How do they all differ? What have they got to do with the 2023 elections? You've heard Mr. Femi Falana, SA, and there postulating on a thing or two, one of those issues that's already making the rounds. That's a number of other issues we'll discuss this morning with Chukwuma Ezala, who is a legal practitioner, joins us here in the studio. Thanks for joining us this morning.
Thank you, and good morning.
Well, you've heard Mr. Falana, and there are a number of people who are wondering along the same line, especially in this whole permutations about whether or not former President Goodluck Jonathan who is qualified or is not qualified, will contest or not contest the presidency of the 2023 elections. Is it an issue of morality or legality?
I think we should first look at the issue of legality before we go into the issue of morality. Because the issue of legality will also look at his own constitutional rights vis-a-vis the constitutional rights of Nigerians, each Nigerian, not vis-a-vis the constitutional right of some vested interest. So number one is to look at, is he really legally qualified to run? I am not among the school of thought that says, oh, sentimentally he's not supposed to run. That's in the realm of sentiment. I have my own sentiments. But I am not to take my own sentiments to overturn the legal rights of individuals. Now, number one is he really qualified to run? This will be looked at when you look at the Constitution. The Constitution, by Section 137, stated those that cannot run. Number one is, after scaling through the other constitutional provisions of your age, political party sponsoring you, and all others, it came into who cannot run. And it says, those that have been elected into that office twice. And that is Section 137, 1B. Those that have been elected into a particular office twice, that is in the case of an executive office, like the office of the president or the office of the governor, or vice president or deputy governor. That is one. So by virtue of that, the question is, has he been elected into the office of the president twice? And the answer is, of course, no. He was elected into the office of the president once in 2015. No, 2011. 2011. He was elected into the office of the vice president in 2007, along with late President Musa Yar'Adua.
Is that to say that when he was elected as running mate, he was not elected together on that same ticket?
No, yeah, when he was elected as running mate, it was as running mate, meaning that as vice, just like Atiku, Alhaji Atiku Abubakar, he was elected as vice president, and he's still qualified to run for the office of the president. He was elected twice as vice president, and he's still qualified to run for the office of the president legally. But he is no longer qualified to run for the office of the vice president. That is in the case of Atiku Abubakar. But in the case of Jonathan, he was elected, one, for the office of the vice president first in 2007, then for the office of the president for the first time in 2011. In 2011. That was his first time he was elected. So the question becomes, having been sworn in to complete the unexpired term of President Yar'Adua, can it be said that he is now barred from contesting for the next election? And the answer is certainly no. He completed, because when you look at that section I just mentioned, you know, the section 137(1)b says when you are elected. Now, we now have the next issue.
Sorry, before we go off that, wasn't his election with the president as vice president also a presupposition that he is a standby president? And in this, in the effect, he eventually indeed became president because he was sworn in as president for 1 year before he contested. Isn't that presupposed that when he was elected vice president, he was elected as a standby president as well?
Yes, he was elected as a standby president. Just like you have now. You have President Muhammad Buhari. You have Professor Yemi Osinbajo, who has, one way or the other, been made acting president. That will not count as if he had become president.
He acted as president. He was not sworn in as acting president.
Let's not get into whether he was sworn in, because ordinarily before you even act as president, you ought to be sworn in. He was sworn in actually as acting president. But that's as acting president, not as president. So you can actually distinguish it between Jonathan taking over.
My apologies. Was he sworn in
as president?
To act as
yes, he was sworn in.
Acting president?
Yes, before you can actually become acting president. It's just like Jonathan. When President Yar'Adua was sick and could not be reached, he was sworn in as acting president first. Then later he was now sworn in as president when it was confirmed that President Yar'Adua could not continue. Before you exercise that office.
But that's a swearing behind closed doors?
Anyway, there is a way it's done, but let's leave that one and follow the main substance now.
Just because a lot of people might say, I didn't see the vice president.
Exactly.
I know it's a detour.
Yes.
But sometimes it's important to clear the air, so we don't just leave it hanging.
Ordinarily, before you start acting, you will be sworn in. Ordinarily.
But not behind.
Ordinarily.
There will be some
Not the type of what you have, not the type of ceremony that you have.
Yes, citizens will get to see some way.
Not really the way you see it, the way. But what is important now is, having been sworn in as the president, not issue of vice president or the issue of acting president, having been sworn in as the president, substantive president, which he acted for 1 year or 1 year plus some months, or 1 year plus some weeks, is he qualified to continue? What the Constitution stated is, if you are elected twice, that's what that section 137(1)b said, if you are elected twice. And when you look at what we may call canons of interpretation was established as far back as 1981 in the case of A.G. Bendel against the AG, Attorney General of Bendel State, and the Attorney General of the Federation, where he said that a particular clause or a construction should not be given of constitution in such a way that it would destroy a particular clause in the constitution. That means you will not start interpreting, the court will not start interpreting the constitution in such a way you destroy the clause. There is a clause that has stated that you will only be disqualified if you've been elected twice. So you cannot bring a construction that will destroy that particular construction. And then we have also what you call, beyond that issue, because when you look at the case that came up when he initially intended to contest, when he wanted to contest for 2015 election, somebody took him to court. In the case of Njoko against Jonathan, he was taken to court, and the High Court said he was qualified to contest under that constitution. It went to the Court of Appeal. The Court of Appeal affirmed the judgment of the court, and the Court of Appeal reviewed all these. He reviewed all these arguments and said he was qualified to contest.
Oh, Mr. Zella,
yes.
I know that as a lawyer you want to build up to maybe the climax, but let's talk about this 137 sub 3.
Yes, that's exactly where I'm getting into.
I'd like our viewers first to take a look at the provision in the law, section 137 sub 3, what it says, because this conversation is basically at least partly based on that particular section. So take a look at section 137 sub 3. Says a person who was sworn in as president to complete the term for which another person was elected as president shall not be elected to such office for more than a single term.
Good. That provision came into effect on the 11th of June 2018. And by canon of interpretation, if you look at section 2 of the Interpretation Act, it stated, subsection 2 of it stated that where no other provision is provided as to when an act will come into effect, it is deemed to come into effect on the date in which it was made. What does it mean? It means that an act comes into effect the day in which that law was made. That does not mean that the National Assembly cannot make the law retrospective. It can, but it more specifically states that it is making it a retrospective act. However, there is a proviso. There is no way you can make a criminal matter a retrospective act. Do you understand? But a civil matter can be made a retrospective act. But in this case, since it's a civil matter, there is nowhere we have seen in the Constitution where the National Assembly or the makers of the Constitution, of course, it's not only the National Assembly that amends the Constitution, where the makers of the Constitution decided to make that particular section a retrospective act. And we also have a Supreme Court to that matter. The Supreme Court of a case of Ojo Kolobo and Alamu. And it states that unless the lawmakers make a law a retrospective act, you cannot read into a law retrospective application.
There are two sides to this, but just to, maybe exhaust. We can't exhaust this, definitely, but just maybe push this further. The law specifically says a person who was sworn in. So the operational word is was, and was is really was, anything in the past. And I imagine that the president at that time was sworn in with the same constitution, the Constitution of the Federal Republic of Nigeria, 1999. Yes. So doesn't that cover as well? He was sworn in with the constitution, and essentially, even though you say it's not specifically stated there that it can be retrospective, isn't it clear enough? Was.
Now, if you say that is the point, you cannot make a law and made it retrospective. Using the word was is just like now. If somebody is, for instance now, if such situation comes in, remember that it will be interpreted back to when he was sworn in. But the law states that you can only reckon from when that act was made. And if you had intended it to apply retrospectively, you would say retrospective. You would say this particular section will be retrospective in application. You will state it clearly. So as long as you don't, you will run into a problem.
You're essentially disagreeing with Mr. Femi Falana, who made that clear, assertion that law can be retrospective.
That law can be retrospective.
Yes.
Yeah, law can be retrospective. I have not said that
So
law
is
cannot.
there you are also talking about the fact that the National Assembly has not put in. Is this supposed to be a clause?
Yes, it's supposed to be a clause. At least when you look at the case, I mentioned.
What part of the Constitution of Nigeria, or what part of it can be retrospective? What is it that determines whether or not a particular law or part of the Constitution can be retrospective?
When the lawmaker states that it will be retrospective, it has to be clear. And that's what I said, the Interpretation Act. The Interpretation Act is a law made by the National Assembly. And that law says that they can make a retrospective act. Do you understand? But they must state that they are making a retrospective act, not by using the word was. The word was or where or doesn't make an act retrospective.
Can you cite an instance where maybe the National Assembly or anyone has cited a clause that says the law must be retrospective?
No, I have cited the law. You know, the law is as interpreted by the courts. And I said by the Supreme Court's decision in the case of Alamu, Ojokolobo and Alamu, which was decided as far back as 1987. It just borders on this, on whether you can interpret a law to apply retrospectively.
What law was interpreted to give that judgment? Clearly not the 1999 Constitution.
No, it wasn't the 1999 Constitution. But the 1999 Constitution is also based on the laws of the land.
So we
had the 1979 Constitution.
Retrospection of some sort.
Yes, no. The canon interpretation all over the world. It's not just in Nigeria. Remember that we are not operating in a vacuum. We are operating within the universal legal system. And within the universal legal system, your own cannot be different. And that is why world all over, particularly in the United States, where we copied our own. If you want an act to be retrospective, you must state it immediately as you're making the act.
So that's one of the issues raised.
But if it's a criminal matter, you cannot. That is it.
That's one of the points raised. And I'm sure this is also subject to the interpretation of the courts. So this is not, essentially.
Did you say subjective interpretation of the courts?
That's subject to
interpretation of the courts. Okay, great.
But is the interpretation of the courts not sometimes subjective, based on perception?
Once the Supreme Court has made a pronouncement, it is the law of the land.
Okay, another detour yet again. But the points Mr. Falana made was not just based on that section 137, sub 3 and 4th alteration. He also talked about Marwa versus Nyako.
Yes.
And then talked about, the court saying that, the Federal Republic of Nigeria's constitution essentially prescribes a single term of 4 years.
Yes.
And if a second term, another period of 4 years and not a day longer. And you did the calculation, as you heard, saying that if the former president were to join the APC and then, of course, throw his hat in the ring and, of course, be running, that means he would have done more than 8 years. He also cited this other one, Ladoja versus INEC 2008, and the court's pronouncement. So,
yes.
Speak to that angle.
Okay, good. You see, these ones were all specific cases of candidates that have been elected and they were going in which they are seeking interpretation of what their constitutional limit is, and the court made those pronouncements. Now, in the case of Jonathan, a court has also made a pronouncement with respect specifically to this. The court made pronouncement in that case of Njoko against Jonathan, in which this issue was canvassed. And the Court of Appeal said, no. Even if it continues, that what is important is to look at that 137(1)(b. That is what the court said. So there is a specific pronouncement in the case of Jonathan. Ordinarily, I would have expected the plaintiff or the appellant to get to the Supreme Court to see whether the Supreme Court would change that decision of the Court of Appeal. But it was not done.
Versus Jonathan.
Yes, in that Njoko versus Jonathan.
That's a tricky one, I see, because clearly it will be quite dicey or tricky to step into this without a clear signal, because the court, first of all, that Njoko versus Jonathan was not exhausted, so someone can institute something and then throw it out.
Yes, somebody can.
So do you think it will be, I don't know, a good calculation to step into this murky water, seeing that it is not clear?
No, it may be good. What is important is to develop our jurisprudence.
You said may.
No, what is important is for us to develop our jurisprudence.
Is that a risk worth taking?
Whoever feels that his right is threatened can do that.
No, I'm saying for the former president now.
Yes.
If he were to go through this, is that a risk worth taking, knowing that it can actually swing either ways.
No, but what is important today is what is the law of the land, especially with respect to him. For him to take. Yeah. I am not President Jonathan. I am not here to converse for President Jonathan. I am only here to state. I have never spoken to President Jonathan. Okay. I am only here to state what I think is the law of the land.
Well, another leg of disqualification is in the contentious 8412 of the Electoral Act.
Yes. Okay.
And there are those who are wondering whether or not political appointees should, go or resign or stay as a pronouncement of a federal high court. And there are those who are wondering where is this all going. Some state governors are already making that move. Some political party made the move, then backpedaled. And what do you make of all of these? Is the 8412 of the Electoral Act, is it still substantive or not?
Great. Now, today, the law of the land is to the extent that the court has set aside this section. That is what it is today, until the Court of Appeal states otherwise. But come to look of it, politicians will always want to put us into confusion.
No, let's stay with the law for a second.
Yes.
You get back to that. We'll come to that. But so there is the pronouncement of the court, right?
Yes,
on that matter.
Yes.
But the further leg to that pronouncement is the order of the court for the Attorney General to delete that section. Is this something within the powers of the Attorney General to do?
I think it's a surplusage on the part of the court. Why I say it's a surplusage, the court has set aside that particular section. So asking the Attorney General to remove and do this, does not really follow.
Is it legal for the Attorney General to do that?
No, what I'm saying is that it is a surplusage, in my view, it is a surplusage on the part of the court has powers to delete that section. So asking the Attorney General or directing the Attorney General to continue to gazette and whatever, is a surplusage. Once the court has nullified that section, and if there is no appeal on it, that section stands nullified. And that means it goes out of the acts of the National Assembly. It's automatic. But if, for instance, the National Assembly or any other interested party is willing to go to court and nullify or set aside the decision of the lower court, so be it. But the point is, the decision of the court alone, standing alone, has nullified that session.
Is that to say then that the state government and any other authority who has told the political appointees to resign, is that an infringement of their rights?
The state government or the state governor appointed them or the president appointed them. They are serving at the pleasure of the government. So if the governor feels that it's going to distract them from their work and ask them to resign now, that's okay. But constitutionally, it's not for them to resign. But if the government, the appointing authority says resign, what else do you need? They will resign because the appointing authority simply feels that they are being distracted.
I know the Speaker of the House of Representatives. Channels Television spoke with him in the UK yesterday about this same matter.
Yes.
And for him, he thought, why go through it in the first place? And I think it just goes back to the point I was making about the former president. Because it's neither here nor there, as it were. You don't know what might happen. So imagine buying forms for how much now? You invest so much into it, you've gone through the process, and then the court says, well, that law actually still stays. So maybe you can tie it together. Would you be advising, those who are in that position to go ahead or just wait this out and resign or drop this office? What harm would you do?
Now, if the court finally decides, if the Court of Appeal, remember it may get to the Supreme Court. Now the question will go back where they qualified as at the time they entered the race. And I would think that the day the court makes its decision is the day it becomes a law. If the Court of Appeal, maybe next month, sets aside the decision of the High Court, it is that day it will become law.
We could go on and on with
this. And remember, it's an act of national, it's not a constitutional matter.
Okay. Even though I wanted to take him up on the politicians and, they get help from lawyers, by the way.
Look, see, today, when we started, he wanted to speak only to the legality.
Not the morality.
Going this way is the morality.
And it's Friday.
Well, Chukwuma Ezala, Well, the court hereby rises.
Thank you.
Chukwuma Ezeala is a legal practitioner. Thank you so much for your time this morning.
Thank you.